All right, welcome back to Bilen and Bellum. I'm Maxime, your host, joined as always by our resident legal expert Ross. So today we're diving into the case of Sergei Pugachev, a Russian oligarch, and the role of trusts in asset protection.
Yeah, that's right, Maxime. So the Pugachev case offers a lot of valuable lessons for anyone considering using trusts to protect their wealth. In particular, this relates to this concept of a sham, which gets banded around a lot. And we've recently done a very extensive video on this concept, which is on the Ballum Law, the Ross Ballum channel, and we'll look at that throughout the review of this case.
100%. So let's set the scene. Sergei Pugachev, a former Russian oligarch, used New Zealand trusts to protect his assets, but the court ultimately ruled that the trust assets actually were not owned by the trust, but they were still his assets and perhaps Sham's Trust. So Ross, can you walk us through the key points of this case and why is it actually so relevant to our listeners?
Yeah, exactly. So the case, as we said, involves Sergei Pugachev. So he owned a very large position in a big Russian bank, and it was alleged basically that he'd absconded with billions of dollars of the bank's money. He was living in London. He had a big chateau in France, which actually he ended up living in. And the Russian government and this bank were basically trying to track him down and get the money back. So I don't know. Obviously, we don't know whether that was political or not, or if he had actually stolen the money. But he had transferred a significant chunk of his assets, something like over $95 million, into 5 separate trusts based in New Zealand. This would suggest that he was worried about creditors. He might have done it for legitimate succession planning reasons. Certainly, if you're moving to the UK, it's very common that you put things into trusts before you move there, because that protected you against inheritance tax, or although that's changing with the change in the laws in the UK at the moment. But New Zealand is well known as a place, particularly for like Latin American people in the past, where they've structured trusts. They use the New Zealand trust law, really because New Zealand is a long way away, and it might be quite hard for somebody to come and take litigation in that jurisdiction. Obviously, a big Russian bank that might be supported by the Russian government has no problem doing that. So these trusts included assets like properties in London. There was a villa and some historical buildings, and at first glance, everything seemed to be in order. The trusts were set up to manage and protect those assets, and the beneficiaries were primarily Pugachev's children. However, the claimants, this Russian bank, the creditors of Pugachev, who alleged that he had owed them money, argued that the trusts were not genuine estate planning vehicles, but were simply a mechanism to hide assets from those he owed money to. And they alleged that he never really intended to settle these trusts, and that they were shams, that they were not valid. He never intended to divest himself of those assets for the beneficiaries. So Pugachev had appointed himself as the protector of the trust. So this is a role that should serve as a safeguard for the beneficiaries. But in this case, it actually gave Pugachev an element of control over the trust. So he could appoint and remove trustees and veto distributions, and even use the trust assets for his personal expenses, apparently. But Pugachev sort of retained, it would appear, or at least it allowed somebody to argue that he was retaining control over the assets. So what ultimately happened was that the court found that there were trusts, but they were bare trusts, which meant that they were just trusts actually for himself. So it's a very interesting case, because it's a bit of a bizarre case, actually, and you can sort of see the political pressures that perhaps the New Zealand government and the New Zealand courts are under. But the judge had to sort of try and find a way to sort of get the right result. So he actually didn't say that they weren't valid trusts. It's just what he said was that the paperwork, the documents around the trusts were invalid, and that what was said on the paper was not the real arrangement. That these trusts were basically being held for Pugachev himself, so that the assets were not owned by these New Zealand trusts.
All right, so there's few things here. The first, it seems at least that the trusts were set up legally, but they actually didn't hold up in court, because maybe through his protector role, Pugachev maybe maintained too much control. And I think another interesting aspect of the whole case is actually involving the email communications, right? Could you maybe tell us a little bit more how those emails actually played a role in undermining Pugachev's defense?
Yeah, I mean, it's really an extraordinary judgment. I encourage anybody that wants to read more to actually just to search for the English, the New Zealand judgment and read it, which you can do. It's actually not too long and written in plain language. But it was bizarre judgment. I mean, at one point, the judge started talking about Angora cats as an analogy, about how, which I had to Google, I didn't even know what that meant. He talking about how an object appears one way, but upon close inspection turns out to be something else, and using a cat breed as an analogy. And you could just see the pressure the judge was under. Yeah, one thing that did undermine it, yes, of course, there was this alleged, retention of control over the assets, which didn't help. But what was quite damning was that there was clearly like a family office that was involved that had some Russian individuals and I think some Swiss individuals. It might well have been a family office based in Switzerland, but the court had access to all these emails, and they were emailing the settlor, they were emailing the trustee, they were emailing the lawyer that had set it up, and they just picked the wording of these things apart to show that he never intended and to actually create a genuine trust and give these assets away. And so, it's email that always brings you down in court cases and in things like frauds. It's always email. You've got to be so careful. In this case, very important things would have been much better done in phone calls or something like that. And anything put in writing, you have to think when you're sending an email that this could one day be in front of a legal dispute, or even worse, actually in a court. So that was one thing. Another really interesting thing in this case was that the lawyer who set up the trust and advised on it is very well known, still has a thriving practice in New Zealand, but he'd actually presented at a conference earlier and had a title about when is a trust not a trust. So, he's a real expert on this sort of sham concept. And that was almost held against him. And the judge, I thought, was quite harsh on him, perhaps unfairly. And what was the most bizarre was that in order for a trust to be found to be a sham, there needs to be a lack of intention really on the settlor's part to follow through with the agreement. There needs to be a sort of element of deceit, that really they're trying to mask the true arrangement with this false one. But also, it's quite clear that there needs to be a common intention with the trustee. So the settlor and the trustee need to both have been trying to deceive other parties. And in this case, the lawyer said, well, I don't know what the settlor really thought. He told me he wanted to set up, but I don't know what he really thought in his head. And the judge said, well, that's fair enough. And the judge even says in the case, I had to really think hard about this. He even says that. And what he concluded, he said, well, I know that you're saying that you fully intended to go to implement the trust. And this is what this lawyer was saying, who was, I think his firm might have been the trustee as well. He was saying, well, even if the settlor didn't intend in his mind, I did. I fully intended to run this trust as the paperwork suggested. And the judge said, well, I'm not buying that. When I look at everything around this case, I'm going to come to the conclusion that your thoughts were actually, your intention was not what you're telling me, but it was the same as the settlers actually. And when I read that, I thought that is one hell of a stretch, isn't it? It really is one hell of a stretch. And I think we've said a phrase a few times in our videos that the bad cases make bad law. And I think we have to put this in this bucket. I mean, clearly there would have been significant political pressure here. Yeah, you've had billions go missing. This isn't just one company against another. This is intragovernmental stuff. And you know how that works. New Zealand might be trying to sell, I don't know, beef exports or dairy exports to Russia. And they might be saying, well, that trade deal's on hold really until this Pugachev thing is cleared up. Hope it's going to go the right way. And right. And not to say that the judiciary are separate, but these things do weigh on decisions. And sometimes it's not easy for a judge. Another factor in this case also as well is that Pugachev didn't turn up to a lot of the court cases. There were court cases in London. He didn't even turn up to them. He turned up to some of them, but I think his view was, I've got the whole Western legal system against me here. There's no point even engaging with it. So anyway, really interesting case. But I think a bit of a shocking judgment. It is now held out as an example of a sham case. It isn't, because that was not what was decided. The judge said there's a bear trust, and then he even says at the end, well, and if you don't, he sort of says like, if you don't believe me that there's a bear trust, well, then they're shams, right?
Exactly. I
Yeah.
mean, I
So
think that was the curious part. He mentioned shams. He's like, yeah, this is a sham trust, then it is not. So he kept on kind of putting himself in a role that he believed that sham trust exists, and then he doesn't. It was a whole back and forth in his head as well.
exactly, and this is the point that I make in our real magnus opus on sham trust, is that the judiciary will never use it, but they'll never throw it away either. And if you're a litigation lawyer as well, you're going to be relying on much more solid legal principles, but you'll always just chuck the sham trust thing in the end. It's almost like give the judge a bone, if the judge wants to come to some conclusion, but the other legal principles don't fit, well, there's always the sham thing. But it's like the absolute last resort. And as I show in my complete history of the sham trust, going back to the Industrial Revolution days, there's probably been only one case where it was used, which was a Jersey case. And again, that's poor authority as well. Again, that was quite a political case. And so, yeah, I don't think Pugachev gives much support to the sham concept at all. Really, this was probably a very highly charged political case involving billions of dollars, and it was a difficult one for the judge to come to a clean conclusion based on solid legal principles.
100% agreed. And I think another really key part of the whole case was about the protector role of Pugachev, and it was all about letting go of control over the assets, right?
Yeah, exactly. And this is what every settler has to go through. There's a balance between making sure that your legal structuring is as tight as possible and retaining control. And you see in offshore jurisdictions, they have these very creative legal devices like reserve powers trusts. These things were designed for like the Middle Eastern market, where it wasn't little old ladies in England setting up trusts anymore. It was billionaire, wealthy Middle East sheikhs. And they wanted to set these things up, but they wanted to retain control. So the offshore jurisdictions came up with creative legal devices, which are fine. And I think probably at the start of a trust relationship, where you're still bedding in the trust, how it works, who's doing what. You're still trying to get comfortable with it. You're getting to know the trustee. Can I trust them? How do they operate? Maybe it's fine, that you retain control, and then I think over time, you might loosen that control up. But it is a balancing act, and it's a simple equation. The more control you keep, even if it's in a role as protector or something, the easier it is for somebody to attack. So you have to balance those two things.
Exactly. And I think it's a recurring theme in our video to really, have a very good relationship with the trustee, and it's a process that takes time. So once again, setting up a trust is not something that you just, wake up one morning and say, okay, my trustee is set up and I'm safe. So it's really a long process. So overall, over this case, Ross, what would you say would be the key takeaways for our listeners who might be thinking about using trust for asset protection?
Yeah, I think you want to think about the jurisdiction carefully. Perhaps Pugachev might have been served better in another jurisdiction if he'd had it. If he'd put a Cook Islands Trust, as I said, there is actually a Cook Islands Bank, which is quite good. And if he'd put $10 million into a Cook Islands Bank and a Cook Islands Trust, that might have been okay. It might have protected it. Maybe the control was a problem. Maybe with the New Zealand Trust, if he had literally given it away to the trustee and the beneficiaries and never had anything more to do with it, that would have given this judge who was already struggling, it might have given him an even bigger headache, right? So, I think you can kind of set your pots up a bit like that as well, right? You set a trust up that you have a bit more control over, that it's maybe a bit easier to attack. But then maybe you have another one, which is you set it up and you never engage in it again. And okay, I've got that lifeboat pot there. It's there for the children and the wife, and trustees doing it, whatever. I am not involved. I have given that away, and that's the end of it. And then I think, as this case proves as well, please be careful on emails. Clients are getting better. In the old days, they used to put terrible things in writing. The number of times I've seen, not so much your court cases, but even more like pre-court action letters. It's happened to me as a practitioner, where all your emails are getting scrutinized by lawyers that are trying to attack you. If you work in a trust company, the next minute your senior management are reviewing your emails from 2 years ago. and what seemed like something sensible then can make you look quite stupid in the future. So be very boring and minimalistic in email. Think, why do I need to send an email? Could this be a phone call? Could this be something else? Because these are written documents that can come out.
100% agreed. I mean, I think, that trusts are really incredibly useful, but they do come with serious, responsibility, like everything. And in this case, in the Pugachev case, it's really a perfect example of how things, can go wrong. And unfortunately, trusts aren't just your, get out of jail free card. And placing an asset in a trust doesn't automatically just protect them from creditors. And like we've seen in this case, the courts will look beyond the paperwork to see who really controls the assets. Would it be in the clever use of protectors, like in this case? And like you mentioned, jurisdictions do matter a lot. Where the trust is set up will really affect it, how it's actually legally treated. And something as simple as email communication can often reveal real intention behind the trust. So it's really important that if those emails show the wrong kind of control, it can really unravel things quickly. So yeah, for me, really the bottom line would be, if you don't have the right people managing the trust and you aren't careful of how it's set up and run, it really can backfire, no?
Yeah, exactly. And I found it very amusing that the poor lawyer in this case, his presentation about Sham Trust has ended up in court against him. So when I was filming my 45-minute webinar on the topic, I did think, oh God, I hope this isn't going to end up in a Sham Trust case against me one day. But yeah, it's a bizarre case. And, what can we say? If you've got a big $1 billion scandal and you've got governments coming after you, I mean, let's be honest about it, it's going to be pretty hard to protect. And, maybe there's some advice there in this case as well, is that, most people who are long-term and generationally successful kind of keep their heads down and don't do things that put your head above the water. I'm not sure if Pugachev agreed. I think he still lives in his French chateau and that, but a lot of stress this man's been through. He might be wealthy, but is he at peace? And is he mentally wealthy? So yeah, it's an interesting case, but I wouldn't give this case too much authority. But everybody does, particularly a lot of legal notes that you'll read that sometimes when you read them make you think they haven't actually read the case, which perhaps they haven't.
Exactly. And I think, Ross, before we continue, we should take a moment to mention the Global Reconnaissance report that Bellum Law is bringing to you. So if you're serious about protecting your wealth, the analysis is your ultimate guide. So it covers everything from choosing the right structure and ensuring your assets are safe across borders. So if you want more information, feel free to head over to the link in the description, and you'll have a form, and as well you can download some samples to see what we do. So Ross, to sum up this episode, any final key takeaway for our listeners?
Yeah, if you do have a genuine threat against you, then you really need to relinquish control over the assets. It may be therefore that you can't use them ever, but it might be that they might survive for your heirs and beneficiaries.
So I think that, wraps it up completely, and we hope you found this discussion around Sham Trust and asset protection useful. As always, don't forget to subscribe, leave us a review, and share this episode with anyone who wants to safeguard their assets. And remember, if you're looking to take your asset protection strategy to the next level, please feel free to check out our Global Reconnaissance report. So that's it for today. Thanks for listening, and we'll see you next week. Bye-bye.